I want to quickly talk to you about succession planning. And if you're a solo firm, you got to really have a clear idea about what to do and what not to do to actually make the whole succession plan for your solo firm really successful. Okay, so the first thing I want you to really understand is that if you're a solo law firm, there are a few things you need to understand in terms of subtlety, what I call operational subtlety. I want to explain to you what a succession plan for a solo firm, solo law firm really is. So a succession plan is actually the process a solo lawyer will follow when transitioning ownership of their firm or closing it down. So you only have two options: either transitioning the firm to somebody else, okay, or closing it down. Maybe you've been around for 40 years. You've been actually working on the firm for 40 years, and you realize that now you don't have somebody to bequeath the law firm to, and you like to close it down. Not a problem. So that's what you will need a succession plan for. Now, this plan can be implemented when the solo practitioner retires, but it can also be put into effect due to unexpected events, right? I mean, stuff happens. I mean, this is life. Things happen all the time. So unexpected events can be death or disability, or just, you know what, you're just tired of working in this industry and you just want to close everything and just start over elsewhere. Okay. So succession plans can also be relevant when a solo practice undergoes a structural change like merging with another law firm. So, anytime you have a change in the legal status of a practice, you can of a solo firm, you can call it succession plan. Okay. So by the way, a succession plan can also happen for larger firms, not just for solo firms. Okay. But in today's conversation, I want to focus specific. I want to talk specifically about solo law firm. So if you have a one person, a one attorney office, how do you do a succession plan the right way? The in a streamlined manner. So it has to be appropriate, and it has to be streamlined. So the thing is that succession planning is important for solo attorneys for several reasons. Okay, and I want to go through those reasons so you have a clear idea what to do. So you want to have a succession plan because you care about risk management, ethical and professional obligations vis-a-vis regulators, but also vis-a-vis your clients. You also want to have peace of mind. Okay, I mean, depending on the size of your solo law practice, if you have a good succession plan, things can be a lot easier for all your key stakeholders. So let me first talk about peace of mind, because peace of mind is quite essential when it comes to succession planning. So solo lawyers have a lot on their plate between running a business and maintaining a legal practice, right? Put simply, putting a robust succession plan means that you will have one less thing keeping you at night, knowing that your practice will be in good hands if the unexpected happens. So, what about risk management? Well, solo practitioners without succession plans in place face significantly higher risk than other attorneys. Think about that. Because since a solo attorney does not have other lawyers to pick up the slack in their absence, any long-term disability due to accident or illness could be disastrous. For example, let me give you an example, like a concrete example. The practice could be left unmanaged, resulting in missed deadlines, damaged client relationships, and even malpractice claims. So these risks may even be greater in the event of the solo attorney's unexpected death. Okay. And you also have some consideration to think about in terms of regulations. So all attorneys owe ethical and professional obligations to their clients, and succession planning ensures that these obligations are met in the event of an unexpected event. So, for example, the ABA Model Rules of Professional Conduct state that the designation of a successor attorney may be a professional obligation for solo attorneys, and Rule 1.3 requires Americans requires an attorney to act with reasonable diligence and promptness in client representation. Comment 5 actually to the rules state that to prevent neglect of client matters in the event of a sole practitioner's death or disability, the duty of diligence may require that each sole practitioner prepare a plan in conformity with applicable rules that designates another competent lawyer to review client files, notify each client of the lawyer's death or disability, and determine whether there is a need for immediate protective action. So now I want to talk to you about the main strategies for solo attorney succession planning. And if you're interested in that initiative, let me know in the comment section, and I can certainly tell you a lot more. But one thing I want to say right off the bat is that the right succession planning strategy for a solo attorney will depend on his or her overarching strategy for ending his or her legal career, right? And so you have here. I'm gonna share with you some of the four. I mean, there are actually four main succession planning strategies for solo lawyers. You have winding down and closing of the practice. You have training a successor, selling the practice, and transitioning to a temporary partner or off-counsel role. Okay, so let me first talk about winding down and closing of the practice. So for either planned retirement or the unexpected, such as death or disability, many solos may choose to simply close their practice, okay? So while you will miss out on the financial benefits of selling a firm, not all solo practices are easy to sell, and closing the business may ultimately be the simpler option, especially if you are in a niche of niches, okay? You're in a particular niche. So either you or your successor attorney could announce the closure of the firm at a future date and provide clients with the opportunity to find new counsel, okay? And so alternatively, you or the successor attorney could wind down the practice by not taking any new legal matters and completing all existing matters. So this is pretty straightforward. So that's for winding down and closing the practice. You also have the ability to train a successor. So that's a possibility. So when I say training a successor, basically you can recruit an associate whom you will then train to be a successor. The associate could eventually be made a partner and then take over the firm upon your retirement. However, this is a long-term plan with some level of uncertainty, since you cannot be certain the attorney will stay with your firm and be up to the task of taking the reins. So another possibility for you could be you selling the practice, right? Selling the practice. So the solo practitioner could also sell his or her practice to another lawyer or law firm. This happens all the time. But this depends on the practice having a client base and types of legal matters that can be transferred to another firm, which is not always the case for solo firms, if you think about it. Because again, we have the difference of niches. Although the attorney could sell his or her practice for a lump sum, often the purchase price is paid out in installments over the course of several years, and the selling attorney may need to stay on in any advisory capacity to help the buying firm retain their clients. Because if you're a solo firm and your clients are used to you and you sell right away, they may not stay, right? So if they're comfortable that you're staying on board, then yes, they might stay with your firm. What about transition to a temporary partner or off-counsel role? This is also another possibility, okay? So some solos may have the option of merging their practice with another solo practitioner or small firm, or being acquired by a larger firm. So the attorney may need to stay on as a partner or in an off-counsel role for some time, and this is an attractive alternative for ensuring client continuity while allowing the attorney to retire on an accelerated timeline, all while receiving the payout for the merger or acquisition. So if you think about succession planning for a solo law firm, let me talk to you a little bit about the key components of a solo law firm succession plan, because there are some key components. For example, finding a successor, entering into a formal agreement with a successor, and also ensuring accessibility of key information. Okay, so once you have determined your succession strategy, the whole process doesn't stop there. I mean, there's a lot more work you have to do. Okay, you need to create your succession plan, and the succession plan has to be as detailed as possible. You can't leave out like a very important sections. Everything has to be pretty granular. At a minimum, your succession plan should contain a few key elements. Okay, so finding a successor, for instance. So you need to designate a successor for your firm, right? It's one of those things where you want to make sure the person is competent, the person is reliable, and the person is credible too. As I said to you a little earlier, your succession strategy might involve the sale, merger, or acquisition of your firm, in which case the successor will depend on you, or but also depend on who is buying your firm. Nonetheless, you should choose your designated successor to take over in case of your unexpected disability or death. And ideally, you should find a successor who works in the same practice area and has little to no conflicts of interest with your client base, right? This is important because you want to build this from a scalable point of view. And also, after finding a successor, you can enter into a formal agreement with the successor. The designated attorney must be able to review files, notify clients, and take necessary actions, including transferring matters to other attorneys. And the formal agreement with the successor should clearly spell out their duties and responsibilities, whether that includes closing or selling the practice. You will also need to address your successor's compensation, because he or she needs to be compensated, okay? And you also need to ensure accessibility of key information. So both the attorney successor and any firm that buys or merges with your practice must be able to quickly access key information. This includes not only client and case information, but also banking and accounting details. So take special care with attorney trust accounts, including IOLTA accounts. Include login information and passwords for computer systems, online accounts, but also software. So if you're a solo firm actually listening to me right now, the big question is, when should you start succession planning? I mean, are you too old? Are you too young to start the process? Everything depends, okay? There is no clear date, there is no clear timeline. But one thing for sure, you need to understand that many solo attorneys make the mistake of delaying succession planning until they are close to retirement. Unfortunately, the unexpected can happen at any time. That's why it's unexpected, right? So if you're a solo lawyer and you listen to me right now, you must prioritize succession planning early in your career to ensure that you have coverage. You gotta have that coverage. Okay. Remember too that succession planning is an ongoing process. You want to review and update your succession plan regularly to account for changes in your practice. Okay. And so this is something you need to start as early as possible. And once you actually have started the process, you need to also inform your clients. This is just pure courtesy. This is like, you got to ask yourself, if you were your own clients, would you have loved for someone to contact you and notify you? Yes, of course. So as a solo attorney, you should be really transparent with your clients about the existence of a succession plan. And so you can use practice management software to help you track which clients you have informed about the plan, as well as legal matter details. Okay. So because as a matter of fact, solo attorneys can leverage technology for their succession planning. Okay. And so one thing you need to understand is that as a solo attorney, you probably have too much responsibility and too much on the line to leave your succession to chance, really. Okay, you can't really do things randomly. You got to be proactive. Okay, that's the thing. Succession planning can buy you a smooth transition, a comfortable retirement, as well as peace of mind. Okay, so the right legal technology can make this process seamless by giving a successor attorney a platform to easily review all legal matters and details on the day-to-day running of the practice. So this is something important, and you want to centralize, you want to simplify firm operations, including billing, calendaring, communication, and document management. Okay, that's really important. So overall, one thing I want you to understand here is that succession planning is not only a worthwhile endeavor for solo law firms, it is vital. Don't don't actually prolong it. Don't postpone it and hope that one day you will be old enough to organize it. No, you do not know what will happen to you tomorrow or even today. As a matter of fact, okay. So without any other attorneys to take on responsibilities in your absence, you must ensure a contingency plan is in place, not only for yourself, not only for your family, but also for your clients. Okay. Again, put yourself in your client's shoes. I want you to use a little bit of empathy and see how you would have loved to be treated if you were a client of another lawyer. And so you also need to, in terms of structuring a succession plan, you must first decide on your succession strategy, whether that is closing the practice, selling it, or some other option. Right? Everything depends on what you decide to actually put in place. Then you must contract with a successor attorney and ensure all details are in place for that attorney to take over the firm. But if you, as a solo attorney, you don't have a succession plan, that's really not interesting, because without a succession plan in place, a solo attorney who suffers unexpected death or disability could leave his or her practice and client matters unmanaged, potentially resulting in errors in or even malpractice claims, right? And you do not want to really go there. Okay, you do not want to go there. And the one thing I want to say also is that planned retirement will also be difficult without a plan to transition out of firm ownership. So that's why I said there is no time actually. The earlier you start, the better. Okay, it's all about starting as early as possible and making sure that you have all the possibilities that are needed, so that all the options also there are needed, just in case of something is not working. At least you know that. Think of succession planning as insurance. Your ability to actually plan for unexpected events. So in conclusion to this conversation, I'll give you a guide to succession planning for solo law firms. Thank you so much. God bless you. I will see you next time. Until then, remember, stay marvelous.